Hello, good afternoon, everyone, and thank you for joining our webinar on Justice Adapting Ontario Practitioners. The presentation will begin momentarily. A few housekeeping notes. We have received a tremendous response to this webinar, and we are hosting a large audience. If you experience technical difficulties, the first thing I suggest is to simply exit the meeting and re-enter it using the link provided. Please note that this session is being recorded, and LexisNexis will distribute the link to the recorded session in a timely manner. On behalf of LexisNexis Canada and the panel, we hope you are all keeping well during this unsettled time. And we thank you for doing your part to flatten the curve. As COVID-19 events unfold, LexisNexis Canada is supporting the legal community by providing free legal news, analysis, and other key resources specifically geared to support your decision-making and counsel on COVID-19 matters. The Lexis Practice Advisor Coronavirus landing page provides a document kit that can be downloaded for free. The Lexis Practice Advisor customers can access this information in the product through the COVID-19 pod. The coronavirus landing page also links to the Lawyers Daily COVID-19 free legal news. Please visit lexisnexis.ca/COVID-19 for more information. Today's webinar will now begin in just a few moments. I'd like to introduce our moderator, Timon Sisek.
Thank you, Laura. Hello and welcome everyone to the LexisNexis COVID-19 Justice Adapting webinar series. I'm Timon Sisek and I'll be your moderator for today's panel discussion. This webinar is a part of a series of discussions LexisNexis is presenting across Canada to bring the legal community together in sharing updates and information about how lawyers, the law societies, and the courts are adapting to the pandemic. Today we are fortunate enough to have with us on our panel 3 lawyers from criminal, family, and civil litigation practices to share their experiences and insights. So, joining us today are Evan Ivkovich, David Amber, and Blake Lingseth. Just a little bit of background on our panelists today. Evan Ivkovich is an associate lawyer practicing at Wilson Vukelich Litigation and Dispute Resolution Group. Mr. Ivkovich's practice focuses primarily on the resolution of commercial disputes, including real estate and construction matters. Prior to joining Wilson Vukelich, he articled at a franchise and commercial litigation boutique in Toronto and practiced as a lawyer at a construction and commercial litigation firm in Vaughan. Mr. David Amber was called to the bar in 2009. Mr. Amber is a member of both the Quebec Bar and the Law Society of Ontario, and he has appeared at all levels of court in both provinces. Mr. Amber has also represented accused persons in the Prince Edward Island Provincial Court, the Manitoba Court of Appeal, and the Court Martial Court of Canada. David Amber's law office deals mostly with alcohol-related driving offenses, but also handles all types of cases at the trial and appellate levels. Mr. Amber's litigation skills have resulted in thousands of successful outcomes and over 60 reported decisions in Lexis Advanced Quick Law. Turning now to Mr. Blake Lingseth. Mr. Lingseth has an extensive academic background, a law degree from Queen's University, degrees in English Literature and Political Science from the University of Toronto, a master's degree in piano performance, and a teaching degree from McGill University. He received his call to the bar in 2001, and Blake is also an accredited member of the Ontario Association of Family Mediators and a certified practitioner in the field of elder law. Mr. Lingseth's primary areas of practice are family law and elder law, and he has a considerable experience as both a litigator and a mediator. Now, I believe everyone listening already recognizes generally the unprecedented impact this pandemic has had on our justice system, so I won't dwell on that. We also recognize that the situation is rapidly changing daily and that the information we have is in flux. However, we believe that open lines of communication within our community are key to ensuring the justice system and its participants remain resilient and adaptive to the challenges ahead. As such, we greatly appreciate the panelists for taking the time to join us today. If the panelists could please share their video screens at this time. Thank you, everyone. The format of our panel discussion will take the form of a question I will ask to the panel and then invite each panelist to weigh in on that issue. Some of the questions will be generally applicable across the practice areas, whereas others may be specific to one of the three. In the last 10 minutes of this hour, we will open up the chat feature of Zoom to allow for questions from the audience. But with that, let's start with our first question. To start us off with an open-ended question to all the panelists, can each of you tell us what has been one of the biggest impacts for better or worse on your practice as a result of the pandemic? And I'll start with Mr. Linkseth on this one.
Well, this COVID crisis definitely has had an impact on business. Business has slowed down. It almost came to a grinding halt. I suppose people are more worried or more interested right now in safety and their well-being, and divorces and separations are put on the back burner. Business has been picking up now. Needless to say, we do not meet clients in person. I resort to Zoom technology, as we're using right now, to deal with clients. So it's a totally different way of interacting with clients, and yes, it has had a negative impact on business.
And Mr. Amber, care to weigh in on what is one of the biggest impacts this pandemic has had on your business?
As a criminal law practitioner, the vast majority of the work that I do is in court. And so since the COVID-19 pandemic began, courts have been essentially kicking the can down the road to see what's going to be happening in the future. And so nothing has been happening substantively in the vast majority of criminal law cases and provincial offenses cases. There are exceptions for cases that have been deemed emergency cases or urgent situations, but I would say that probably between 90 and 95% of all criminal cases are not being dealt with in any substantive manner until at the earliest the end of this month, but it's even looking like trials won't even take place until the month of July. And so with that, of course, comes the related issue of billing, of course, is that the criminal law practitioner, the vast majority of our work is litigation in court and other court-related substantive matters. And so not being able to do that has led to a slowdown in billing, which has its effects, as Blake mentioned, on the business practice as well.
Okay, thank you. And Evan Mr. Ivkovich, from the civil litigation perspective, is it similar, or is there anything else you'd like to add with respect to the effects of the pandemic on your practice?
So I would echo David's answer, which is that the closure of the courts has had an obvious impact on litigation. Matters that otherwise could be moving along are simply not. And other than that, I guess the other biggest impact is that I'm doing a lot more of my work in sweatpants than I did before.
Well, that brings me to my second question here. Are you working remotely, or what office precautionary measures are each of your firms taking? And if you can describe some of those precautionary measures, and I'll turn to Mr. Linkseth on that one.
Well, we work with a skeletal staff. My associate works exclusively from home. I find a need to come to the office every day. Once again, we don't meet clients in person, but I think I lack the self-discipline to work from home, quite frankly. One assistant is here, and we always practice safe social distancing. We certainly are taking this COVID thing very seriously. Absolutely.
Thank you. And Mr. Ivkovich, have you had a different experience? Are you working from home, or are you ever in the office?
So I've been working exclusively remotely, as of many from my office. My office is open for lawyers and staff to come in, but there's a maximum number of people that can be there on any given day. And people need to provide advance notice of when they intend to come into the office, and everyone is expected to practice safe sanitation practices when they're there. And as for clients, same thing as Blake. If you're going to be speaking with a client, it'll be either done through video conferencing or a telephone call, or emailing, obviously.
Okay, thank you. So our next question is about the potential way of turning this into something positive. So when business is good, we all know that caseload can get overwhelming, and as practitioners, it might feel like you are doing catch-up all of the time. On a positive note, have court closures been an opportunity for you to catch up on files, especially considering opposing counsel cannot push court dates along, except in civil cases, in urgent cases? I'll start with Mr. Amber on this question.
Well, with the extra free time that I find that I have, I mean, there's been opportunities, in some ways, opportunities that we might not ever see again to catch up on certain types of things. I've been able to do some independent reading in terms of areas of the law that I wanted to broaden my understanding. But as it pertains to some of the more practical issues related to cases, it's allowed me to focus on some cases that are coming up more towards the fall or the winter, and begin working either on trial preparation or some of the written work required for appeals. It's also been an opportunity around the office for both myself and my staff to work on some of those little tasks that might not have been given any priority when we're in the busyness of a day-to-day practice. For example, we've been building our research library. We've also been better making use of organizing our files. And so it's been an opportunity to do some of those little things, and even in terms of work-life balance, get some exercise, read some books, broaden one's horizons in ways that we normally wouldn't do during the busyness of a day-to-day practice.
Okay, thank you. And Mr. Ivkovich, on the civil litigation side, have you had more time to catch up on files?
Yeah, definitely. And I think now is also a great opportunity to do some marketing work in terms of, say, being a panelist on a LexisNexis webinar, or writing blog posts or articles, and expanding your knowledge of different practice areas, definitely. And also what David was saying about now is a great opportunity to get some exercise. I mean, the weather hasn't been that great for May, but you can still go outside, go for a run, a socially distant run. Yeah.
Okay, thank you. And Mr. Linkseth, anything you'd like to add? Any opportunities you've taken to catch up on outstanding work, or just catch up on some exercise, if you will?
I start by saying that stating the weather isn't so great this way, that's an understatement. It's been horrendous, hasn't it? But here in Ottawa, at any rate. No, David and Evan could be kindred spirits. I echo what they said. Yes, I've been reading up on different subject matters. I'm trying to move more into wills and estates, and I'm learning a lot about that. I've been doing a lot of blogging on my website. I've been catching up on files that were sorely neglected. The trick is, when the world around you has come to a grinding halt, the trick is to stay motivated, isn't it? You've got to do something. And so, like David, like Evan, I try to make the best use of my time possible.
On a related note, what steps have you been able to take to move your matters along, considering the court closures, especially those where it's in the client's interest that the matter does move along more quickly? Have you utilized any creative methods to, so to speak, keep the pressure on and make sure that that these files don't end up dormant? I'll start with Mr. Ivkovich on that question.
So to be honest, I'm not sure that there's much you can do unless your matter is urgent or falls under one of the limited exceptions for remote hearings. Discoveries can, in principle, be done remotely, but I haven't done or seen it on my firm. I will mention that there is a recent case, Conti and Smith, where Justice Myers ordered that examinations for discovery be done remotely, despite the plaintiff's position that it should be done in person. So you can perhaps point to this case if opposing counsel is insisting that examinations be done in person at a later date. You can obviously commence a claim electronically. You can have the process server serve it, but ultimately procedural deadlines are suspended, and there's really not much you can do to push things along as of now.
Okay, thank you. And Mr. Linkseth, on the in the matter of family law matters where things can move fairly urgently, or some remedies can't be put on pause, is there any unique strategy that you'd have to keep matters pushing, keep matters moving?
Yeah, I agree with Evan. One is limited as to how you can move matters along when the courts are closed. You can govern yourself accordingly letters full of sound of fury, but signifying nothing, you know. Having said that, the courts, although they're closed, urgent family matters are being heard. You have to, and maybe this is going to be a different question, Timon, and I'm jumping the gun here explaining, but
oh no, that's all right.
If you deem something's urgent, and in the family law context, urgency comes up quite often in parenting arrangements, one parent stopping or severely restricting access because of the COVID pandemic, you send parse down materials to a triage judge who then determines whether or not it meets the level of urgency required. But the judges are hearing quite a few cases. As of yesterday, in Ontario, in the family law context, in the CAS context, there were over 260 cases that have been heard during this COVID pandemic. That's quite a few. And judgments are coming out very quickly, much more quickly than pre-COVID.
Yeah. Okay, thank you. And Mr. Amber, I know it's a different context in your practice, but are there any situations where something needs to move along quickly and you have to find a creative way to move it forward, or is that not applicable in your case?
Well, I can give one example that happened towards the beginning of the shutdowns of the courts, is that I had a client of mine who was found guilty of an impaired driving offense, and we immediately filed an appeal. And what would often happen after that is we would file an application to stay the driving prohibition pending the outcome on the appeal, because obviously an appeal can take 6 months to a year or even more. And if a person serves out a 1-year driving prohibition and then ultimately they're found not guilty, that is a situation where you can't remedy that. And so this procedure exists. Now, we began the process of filing the materials, and then the courts closed. And so I found that the court was actually very accommodating in hearing that matter in writing and granting the order in writing. I've had another situation as well where a trial matter which was scheduled in the Superior Court, which obviously didn't go, the court was very accommodating for working at a judicial pretrial and a resolution. We did a plea by telephone. And so there have been some ways to move matters along. I did one appeal in Quebec where the judge insisted on taking the materials only in writing and asked any questions that she felt she had about the materials. And she was able to turn around a decision yesterday, in fact, and granted our client's appeal of conviction, entered an acquittal.
Sorry, you mentioned it was yesterday. What was the turnaround time on that? I wasn't.
So I believe it was the 21st of April was when we would reply to the questions that the judge had, and I believe by the 24th of April we submitted any further written materials based on what the parties had said about the questions the judge had, and the judge had a decision. It was a fairly lengthy, I believe, 13-page decision. It was a fairly narrow issue, but it involved a lot of law, and so the judge, turned that around relatively quickly.
So it sounds like the message I'm getting here is if you can get your matter before the courts, you're going to receive some pretty efficient service. So That's
right, and I think you're going to need to make the case as to why your matter needs to be heard. You've got to be, I guess, the greasy wheel that gets the oil, and you have to make a good reason as to why. I mean, sometimes the reasons, like the appeal decision, this is a matter of practicality. It was scheduled for hearing the week that the judge decided she was going to ask for submissions in writing, and so we got that off the books. In other cases, though, where the urgency is higher, if you make the case for that, I think the system's been pretty receptive to that.
Okay, thank you. Next question is more so administrative and office related. So a lot of support staff's work involves working to assist in preparing court documents. And I know this was touched upon a little bit earlier, but if you can elaborate, has your firm been able to keep your support staff busy? What methods has your firm utilized to be able to best utilize your support staff? And I'll start that with Mr. Linkseth.
It's been difficult. There's less work to be done, but here again, there's lots of catch up to be done. So a lot of filing, reorganizing. But yes, it's there isn't the workload there once was, as I said before.
For sure. And Mr. Amber, have you experienced the same thing with respect to support staff?
Well, I've touched on it earlier, and I think it's a matter of maybe attending to some of those tasks that we wouldn't have ordinarily found the time to do or to prioritize. I mentioned the fact that we've been building and developing our in-firm library of various publications that we received, and so my support staff's been very helpful in doing that. And also sometimes some of the more rudimentary tasks. I mean, we've been closing a lot of files, boxing those files up to get those out of the office to make more space, clearing up some workspace that has had old files or closed files in it for some time. So we've been using it as an opportunity again to attend to some of the tasks, small and large, that we might not have had a chance to look at.
Okay. This question was touched upon a little bit earlier, so I'm going to modify it here. But I suspect that attaining new clientele, as you had mentioned earlier, has slowed down quite a bit, though I'd be happy to hear any stories to the contrary. I just wanted to hear to what extent you believe that this might start picking up. Have you experienced anything picking up in terms of more business, or do you expect in the future that there might be a wave of new clientele coming in after things settle down a little bit more from this pandemic? And I'll turn that to Mr. Linkseth.
I think I mentioned that even now business has been picking up somewhat. I think once we get past these harrowing times, it will pick up very quickly. I heard a sad statistic that cases of domestic abuse, domestic assault have gone up significantly, substance abuse, relationships that are already on precarious ground, being together 24/7, unable to get any reprieve, any respite, that's going to lead to a lot of relationships breaking down. So I've heard. So I am expecting in the family law domain, I am expecting there'll be quite a spike once we get past this COVID era.
And Mr. Amber, do you expect any similar spike in the criminal law area, or do you expect that it should be more or less the same?
Well, there are a few dimensions to this issue, Timon. I echo some of the comments that Blake just made earlier. I mean, I don't see necessarily the family law side of things, but there is often an overlap between domestic assault charges. Now, I haven't seen in practice an increase in number of calls. The number of calls has stayed roughly the same, or maybe gone even a bit lower than normal. Things like impaired driving, which is a large part of my practice, since people aren't out on the road as much, there's been a drop in that as well. So I'm hoping to see an increase in that regards. One of the other dimensions, though, to it is that a lot of times when people hire a criminal lawyer, it's hiring somebody and coming up with money for an expense that the person maybe hadn't in any way contemplated the day before they got charged. And so in many situations, people, when they want to retain a criminal lawyer, will tap into savings or get some of the good faith assistance from family members. And because everyone's finances are stretched right now, we may see, at least my theory is that we may see an increase of people representing themselves or not having any resources to be able to hire a criminal lawyer. And so that's something that's of a concern. I will also mention that there's going to be an increase in some of these provincial offenses as well. I'm currently representing somebody who was in the local papers for having gotten into an altercation with a bylaw officer, and the allegation that the bylaw officer struck my client in the course of alleging that my client was committing a COVID-19 related provincial offense. And so we're going to be disputing that charge, and I've been getting some consultation regarding those. It's not going to be the largest part of my practice for sure, but it's definitely going to be a new aspect to my practice that we're going to see play out over the next few months.
Okay, thank you. Have you, your colleagues, or your support staff had to familiarize yourselves with any new technology in order to adapt to the situation? So anything from cloud sharing of documents to any other types of communication, or anything you've had to change or learn anew? I'll direct this one to Mr. Ivkovich first.
So I would say that even prior to the pandemic, my firm had the infrastructure in place for remote work. So the transition has been relatively smooth. Lawyers have work laptops with VPN access and a robust e-document management system that's easily accessible through our laptops. My firm also has an internal IT person that's been responsible for the transition, and he's available to address any issues that come up. So, and I've always been very comfortable with technology. So, for me, and I think the firm as a whole, relatively smooth transition, as much as it can be, given how sudden it was.
Right. Mr. Linkseth, have you had a similar experience, or was there any other type of learning curve with respect to technological adaptation?
Relatively smooth transition. I'm a bit of a Luddite, so it took me a while to gain a certain facility with Zoom. Participating as an invitee is one thing, but hosting a Zoom meeting is a different kettle of fish. So it took me a while to get used to Zoom, but apart from that, smooth. Okay,
thank you. My next question is a little bit more of a substantive nature. We did host a similar webinar in Saskatchewan and in Manitoba with the justices commenting on their court systems. So I had a little bit of a touch over there, which prompted this question. Other provinces have reacted differently with their court systems closures. Saskatchewan and Manitoba, for example, still have some in-person hearings. Do you have any comments with regards to how the courts are handling the crisis in Ontario? And are you satisfied with the steps that have been taken so far? And do you want to see courts start opening sooner, or are you happy to see the restrictions in place? I know this was a bit of a multi-part question, but I believe you get the idea. So I'll start with Mr. Ivkovich on this one.
So I would say I think that the attitudes among the Ontario judges and the legal community at large when it comes to incorporating technology more into the administration of justice and the practice of law has been, generally speaking, encouraging. But ultimately more can, and I believe should be done in terms of doing this. As of now, at least for civil matters, only urgent matters, I believe matters on consent, Rule 7 motions, select pretrials, and select divisional court matters can proceed remotely. And I believe that you still need to submit written materials once the courts reopen. So, but it comes down to building the infrastructure, because we don't have the infrastructure in place right now. And that it will come down to what kind of resources our courts have in terms of building that infrastructure. So I will say that it'll be a challenge to say become, for example, paperless. That's one type of way you can advance the technology. But this still needs to be, I think, a whole scale revolution of practicing law. But that's the young millennial lawyer perspective when it comes to that.
Okay, thank you. Just to add to that, in Manitoba, for example, they already have a schedule for reopening. So that's the approach that they're currently taking. Mr. Linkseth, do you have any comments on what you would like to see the Ontario courts do? Are you happy with the current restrictions that are being placed, or do you think they're too aggressive, or not?
It's a tough call, isn't it? I mean, there's a lot of pressure to get things back to normal, to get the economy back to normal, to get the court system back to normal. But I believe that here in Ontario, one of the hardest hit provinces, if you open up things, if you loosen those restrictions too soon, then all the sacrifices made to date will have been for naught. We're back where we started from, if not more so. You start opening up the courts now. How do you control safe social distancing within the courthouse? I think it would be very, very difficult to do. Perhaps in the courtrooms, yes, but around the counters where you file materials, whether it's family materials, estates, what have you. Usually that's a zoo. I guess what I'm saying in my convoluted fashion is that, yeah, no, I agree with the approach taken by the Ontario courts, where we're at compared to where Saskatchewan's at. Saskatchewan was not hit nearly as hard as Ontario was by the COVID-19 virus. I think, and correct me if I'm wrong, any one of you, I think we're now slated to open in early July for in-person hearings. Now, that is always subject to change depending what transpires over the next few weeks, I suppose.
Okay, thank you. And I'd just like to turn this over to Mr. Amber. I'd also do recognize that none of us here are medical professionals as far as I know, but I would ask if are you satisfied with the way that the court has and the government has taken steps with respect to the court system to address this, or would you like to see it going further in one direction or another?
I think I understand the question. I mean, I see sort of two questions contained within it. One of the questions being, have we been making good use of technology? And two, have we been moving forward to coming to business being back to normal again? And I think that there's been some pros and some cons to both of those, or maybe not pros and cons, not the right word, but there's been some wins and some losses in both of those regards. I note that before COVID-19, the court was actually, at least for criminal cases, very behind the times in terms of making use of technology. There is a large number of routine appearances that could be done and could be facilitated to improve the administration of justice by video, and there's been, to my knowledge, a large resistance in doing so. This may be a good step in moving in that right direction, and to the extent that we have been using those video appearances, that's been a positive thing. I've had some good experience with it. Although on the other hand, I think we could have been doing more. I also note that in terms of returning to business as usual, again, we're not getting some clear directions as to what our plans are and how we're going to do that. I know I had a case management conference with a judge of the Court of Appeal and was quite surprised that the judge was surprised that we thought that any case would be heard in person until the new year. I mean, both the Crown and myself weren't aware of anybody anywhere in society taking the position that things won't go back to normal until the new year. That's at least what one justice of the Court of Appeal felt. So, I mean, there's a lot of uncertainty right now, and so I think I couldn't really fully answer the question at this time.
Right. So it's a mix. Yes.
May I add something, Timon, with that?
Of course.
Okay, yeah. I just hearing what David had to say and what Evan had to say made me think that possibly there might be a silver lining to be had when it comes to the justice system. It's we were stuck in the 20th century here in Ontario, at any rate, and this has caused us to forced us to move into the 21st century, the way we deal with certain things and certain matters. And I hope that video conferencing is here to stay because I agree with David. There are certain things that could be taken care of via video conferences as opposed to in-person appearances. Not everything, of course, but some things. And there is going to be a tremendous backlog once this pandemic is over. I mean, there was already a backlog, and I think they're going to need all the resources, including the new technology, to contend with this tremendous backlog.
Okay, thank you. So the next question is somewhat related, a little more specific though here. Limitations periods in Ontario, as you know, have been suspended until June 14th, while they have not been in other provinces, and that was a choice made. What are your opinions on this, especially considering that the ability to issue claims online is still available? Should limitations periods be, if it were up to you, should limitations period be resumed prior to June 14th, or do you think the suspension will and should be extended? And I'll start this question with Mr. Ivkovich.
So I think that overall, the suspension of limitation periods and procedural deadlines in Ontario has been a good thing. I mean, I appreciate that you can file a claim electronically and have it served, but at the same time, a lot of clients are hurting financially. And even if a claim can easily be filed online, clients are going to pay the legal fees. So it would be unfair to put a client in a position to have to choose between incurring fees when they may have more other pressing concerns for their business, or losing a valid claim due to an expired limitation period. And obviously, I understand that lawyers can reduce their fees or delay collection, but suspending limitation periods is a more elegant solution. For plaintiffs, litigation is typically slow moving in any event. And there may also be reputational concerns for institutional clients. And this answer obviously is with the caveat that I'm giving the perspective of a civil litigator.
Of course. And Mr. Linkseth, do you share the same sentiment, or would you like to see limitations periods extended, or sorry, excuse me, the suspension on limitations period extended, and do you think it was a good idea?
Well, limitation periods aren't all that relevant in family law, quite frankly. Mm-hmm. So I'll just bow out of this question.
Okay.
I don't have anything to offer there.
For sure. Anything with respect to Mr. Amber or Mr. Linkseth, with respect to filing deadlines, because those have been suspended as well. Do you believe that that was an appropriate move in this instance? And I'll turn that one to Mr. Amber.
I'll just say one thing. I'll use this as an opportunity to try and raise some awareness. The Ministry of Transportation of Ontario has been notorious for not following the requirements of it under the Highway Traffic Act. And we're seeing an example of this, or we're seeing an example related to this right now during COVID-19, is that all limitation periods across the province have been extended. And yet, when someone wants to plead guilty at an early opportunity within the first 89 days of being charged with an impaired driving offense, they qualify for a certain early reinstatement of their license. And the Ministry of Transportation has been very slow to respond and has not yet fully responded as to whether or not they're going to allow that to take place. And so certainly any practitioners who deal in this field should be pressuring the Ministry of Transportation and communicating with them, take a position, and quite frankly, a reasonable position on extending that, that limitation in a manner consistent with the court limitations.
Okay, thank you for that. Mr. Linkseth, I know with respect to the limitations periods, that's a different story, but with respect to filing deadlines, have you found that useful, or do you approve of the message?
Yes, I do. I mean, there are obstacles, obvious obstacles that present themselves when you're trying to organize and swear responding materials. Extending deadlines is the norm anyway in family law. There'd have to be awfully good reasons for a judge not to allow an extension of time, a consent to late filing for materials. So yes, I think it's appropriate in this day and age.
Okay, thank you. This is a question for Mr. Ivkovich. Mr. Ivkovich, have you seen an increase in COVID-related civil litigation, such as, for example, employment litigation or bankruptcy litigation, either in your practice or in the practice of your fellow colleagues in the civil litigation sphere?
So I will say that the employment law group at my firm has been busy, and I've assisted on some employment matters, even though I practice primarily in commercial litigation. I think I've seen an uptick more so on advisory work in the area about, for example, how to handle COVID-related layoffs, or about what constitutes an essential business. As for bankruptcy, I think that bankruptcy will see an uptick later down the line, but I think most businesses are trying to at least weather the storm for now. But we'll see the real impact financially on businesses when it comes to COVID. Not right now because it's still too fresh, but it's going to happen.
Mm-hmm. Okay, thank you for that. We'll keep an eye on that. So our next question is, have you experienced or do you expect to experience a rise in settlements, mediation, arbitration, or plea deals motivated by court closures during this time, or any of the impediments that the pandemic has implemented? If I can elaborate on this question, has there been a renewed appetite for settlement or mediation or early resolution as a result of the fact that the courts are more difficult to access? And I'll start that with Mr. Lingseth.
Yeah, there is more pressure on people to settle, absolutely, because what other option do you have, right? Mm-hmm. At this point in time, unless it's very urgent. I'm also an accredited mediator, and I've seen a bit of a surge in business as far as mediation goes. I've been conducting mediations successfully via Zoom. So yes, because court right now is not a viable option. People are trying a bit harder to settle matters. People are resorting to mediation, which has always been encouraged anyway in the family law context, but trying mediation as well.
Okay, thank you. And Mr. Amber, I know from the criminal law context, have you experienced anything with respect to your communications with the Crown, or has it all been the same?
Well, generally speaking, a lot resolves in criminal law, but a lot doesn't, or at least in my practice, a lot of it doesn't. And why that happens is when the parties take positions that are irreconcilable. It's that classic unstoppable force meets a movable object situation that results in trials being set. And so I have a lot of trials that are coming up in the near future, or that have come up during the pandemic period. And those have all been postponed, and the future trials are all in question as to whether or not they're going to go forward. And when matters finally resume, we're going to have a backlog of cases that are going to have to be assigned, particularly in custody matters, which will be given priority. And so we may see a situation where trial matters are going to be pushed way into the future and be at risk of being stayed for unreasonable delay. And so that context provides incentive for the parties who were previously that unstoppable force or immovable object to reconsider their positions. And I have, to the credit of many Crown offices in both Quebec and Ontario, been receiving a lot of very favorable resolution positions that are been referred to both by Crown and Defense as a COVID special, so to speak, positions that the Crown might not normally take given a particular case or set of facts, but one that they're willing to take when considering all of the normal considerations, in addition to the backlog risks of a case potentially not being heard until 2021 or 2022, and then in those circumstances being at risk of being thrown out due to unreasonable delay. So that has produced opportunities, and I note that the Ontario Court of Justice is now requiring parties to come together to discuss, and so there appears to be incentives for everybody to try and resolve matters and clear the deck, so to speak.
Okay, excellent. I'll turn this next question directly back to you, Mr. Amber. Can you speak about your experience in preparing for trials during COVID-19 or during the pandemic? For example, have you experienced any issues with respect to summoning witnesses or obtaining productions? Has anything changed from the perspective of preparing for the ultimate trials?
Maybe a better time to have asked me that question would be in about a week from now, when we know a little bit more about what in practice is going to be happening with those early trials in late June or July. For now, my trial preparation has been the same, only ground to a halt essentially. Nothing has really changed because, like I said, trials aren't really happening, so I don't really have an answer to give.
Okay. And Mr. Linkseth, do you have the same experience with respect to, yeah. Okay.
Trials are not happening, and I don't think anyone could conduct a trial via Zoom. That's not something you can do via video conferencing.
Right.
So no trial preparation.
Okay. So another logistical question. Have you experienced any difficulty in office logistics during this pandemic, such as simply a shortage of office supplies, interruptions of service persons, interruptions of process servers? If so, how did you handle these? And I'll start with Mr. Ivkovich.
So I'm going to say generally I haven't had any real issues with office logistics. Yeah, everything's been fine in that regard. Okay,
thank you. And Mr. Linkseth, anything on that front?
No issues. We've always ordered online, so it's been running smoothly in that regard.
Okay. This is a question that's been coming up generally speaking across for employers even outside of law firms, but do your firms use software to monitor their employees' activity when they're working remotely, or is everybody simply responsible for their own work? And I'll turn that one to Mr. Ivkovich.
So I'm going to say, if my work has been monitored, I would not know. I'm not privy to that.
Okay.
I mean, generally, I kind of take the initiative to keep track of what I'm doing myself. I haven't really had any issues, but I'm also not the person who would, be aware of that.
Right. Mr. Linkseth, for yourself, is it the same situation?
I have a very small team, and we get along like peas in a pod. It's almost like a second family. So there's no reason to monitor. That I certainly haven't been monitoring my. I'm in touch with my colleagues on a daily basis, whether or not they're working at home, but no need to monitor. No.
Okay. Okay, great. Just speaking of more of the technology side, while we're on that point, can you touch on any of the security tips regarding confidentiality of documents, the video chatting? I know there was a big controversy with respect to Zoom having hackers joining uninvited onto particular platforms and things, and I understand that that's since been fixed. But have you had any concerns with respect to confidentiality, either of documents or of communications at this time? And if so, what would those be? I'll turn that to Mr. Linkseth.
Well, we've always had a very good virus software. I guess my biggest concern is Zoom. I do recall there were problems with encryption, and hopefully that's been worked out. Obviously, you're taking a bit of a privacy risk at any time you go on the internet, but as opposed to in-person meetings. But what's the alternative, right?
Right.
So you've got to assume a little bit of risk and try to minimize it as much as you can. I mean, on Zoom, for example, you make sure that that it's a private meeting, that you have a password, that you change your meeting ID on a regular basis. Those are some tips from Zoom.
Okay. Well, if there are no further comments on this from any of the panel, I'd like to open it up at this time for questions from the audience. Laura, if you could open up the chat box, and in Zoom, if you click down on chat, you can submit your questions and I will ask them to the panel. I'll select questions here. So we have a question coming in already here. What do the presenters think will have to happen before we will put more than 5 to 10 people in a courtroom to conduct a motions list, bail court, or purge list? And feel free to jump in if you have any opinion on this question.
I think this largely is tied to the way the province is going to be moving things forward, generally speaking, with the economy. I mean, we had some objectives in place, broadly speaking, as to why we shut down. For example, trying to slow the curve and not overwhelm the healthcare services, and also to protect certain vulnerable populations. I think when we get to the point where those concerns have either passed or where they are manageable, I think then we're going to see things open up, and I don't see any reason why we couldn't reopen the courts.
Okay, thank you. The next question here, and I know the Law Society has commented on this, but briefly, if each of you could identify how you handle identification and verification of clients. And I'll start with Mr. Amber on that one.
Well, for criminal law practitioners, we don't really do the verification. There's a number of criteria that the bylaw requires in order to do verification, and generally speaking, those criteria don't apply to me. So the identification requirements do, but that's a matter of simply just collecting the information. And so there hasn't been a change for me and most criminal practitioners.
Okay, thank you. Mr. Ivkovich, Mr. Linkset, do you have any tips on identification, client identification?
Well, we ask new clients to scan, provide us a piece of photo ID, and when you're Zooming, when you're having a meeting via video conference with this client, you can check the identity at that point. But that's about it.
Okay. Mr. Ivkovich, this is a specific question for you. Could you please repeat the recent court decision on discoveries proceeding remotely?
Yeah, so actually what I was, I noticed that question as well, and I was going to type into the comment, the chat section, the actual name of the case as well as the citation. So I'll just type that in and it'll be available for everyone to look at.
Okay, thank you.
I think it's the simplest way of kind of sharing the case.
Okay, we have a question here. What do the presenters think will happen with those cases that were scheduled to proceed to court or tribunal hearings during the shutdown when in-person hearings are reintroduced? Will they be given priority for early scheduling dates and priority over new matters? I'll turn that to Mr. Linkseth while Mr. Ivkovich is typing out the citation there.
Well, certain matters that had been scheduled during this COVID period and were adjourned, obviously, they are being rescheduled in June. A lot of them, I'm talking case conferences, settlement conferences, they would happen via video conference or teleconference now. So they're trying to get rid of some of the backlog in June. That'll be a starting point. Matters that had been adjourned will take priority, yes. And goodness knows when new matters will be heard. It could be quite a while.
Okay, thank you. This question is for Mr. Amber. Do you perceive that the Ontario Court of Justice may permanently continue with virtual guilty pleas? I have the same question regarding virtual remands. Why not get rid of the remand system while we are at it?
I saw a few questions, Timon, about virtual pleas, and so I'm going to try and answer all of those at the same time here. Unfortunately, my answer could be more fulsome again in about a week or two from now when we know a little bit more about what some of the next steps are going to be put in place. But I think there's an appetite to conduct those types of pleas that are on consent or rather joint submissions. I think those are the types of things where as long as the court can ascertain that the plea is voluntary, unequivocal, and it informed there's really not much of an obstacle to proceeding forward with that. While I have the floor, Team, I could also maybe just address one other question briefly. I saw 11B. Obviously, there's going to be delays and there's going to be matters that fall outside of the presumptive ceiling. What that means is that they're going to be essentially too long in the system and should be presumptively thrown out unless there are exceptional circumstances. To this, the Crown is obviously going to argue that COVID-19 constitutes exceptional circumstances. And so it remains to be seen how that's going to play out. I think the closer you get to mid-March or April or early May, the easier those periods of delay will be to call them exceptional circumstances. But the further we get away from that, the harder I think it will be to convince a judge that that delay occasioned was as a result of exceptional circumstances. So that's the approach that I'm looking at. I'm going to be looking at cases that have been delayed largely past early May and see what happens there.
Okay, I'd just like to add with respect to the question regarding remanding guilty pleas. We do have a similar webinar with the justices of the Ontario courts, and just that have, and that was a question that came up as well. It seems from my recollection that there is an appetite for that, as was stated by the judges at that time. So I encourage anybody that wants to hear the opinion of the judges on that to take a look at that webinar on the LexisNexis Canada website. This question is for civil matters. With regards to urgent civil motions, the standard stated to pass through the triage is serious financial consequences or hardship. Can Mr. Ivkovich in particular advise on whether this is a subjective or an objective standard? A dispute where $10,000 is at stake may be urgent to some or not to others.
So I will say that my experience with urgent civil motions is limited to essentially one, which was to pay funds into court to vacate the registration of a lien on a large construction project that would have impacted the flow of funds to many parties, including trades. But I think that's a really interesting question. I think, in my view, it would be closer to what you may want to call the subjective standard, in the sense that you need to demonstrate the serious financial consequences to the party bringing the actual motion. And I think that ultimately that's relative to the party's circumstances.
Okay.
You could also point, maybe you could even try to point to other parties too. Why not, right? There's not well-developed case law when it comes to what constitutes urgency during the pandemic, right? There's plenty of room for making those types of arguments.
Mm-hmm. Okay, thank you. And I'd just like to point out, I know that we had a small amount of time for quite a lot of questions coming from the attendees. Mr. Amber has posted his email address there, ask@davidamber.com. If anybody doesn't get their question answered, there are quite a few here, so it's very, very likely. Okay, this one was answered here. This is another question for civil litigation. Do you think that the principle of frustration will have a chance in a commercial lease agreements for small business tenants who can no longer afford to continue their tenancy, in particular in non-essential business tenants? I know that's a very substantive question there, Mr. Ivkovich, but a brief opinion.
I'm sorry, could you repeat that? I was actually distracted by some of the comments looking for the case.
Okay.
Yeah, sorry, could you just repeat the question really quickly?
Sorry. Do you think that the principle of frustration will have a chance in commercial lease agreements for small business tenants who can no longer afford to continue their tenancy, in particular non-essential business tenants?
Yeah, I definitely think that's a valid argument to make. If the entire purpose of your lease was to operate a certain type of business that you cannot run anymore, then I think that's definitely a valid position to take.
Okay. I believe this is directed to Mr. Amber. What are the file sharing systems your firm is using? Which ones do you find best?
Well, I'll start by saying that I made the decision pretty early in my career to scan or save everything that I receive to an electronic file structure. And I've used a variety of different file sharing or synchronizing systems. The one that I'm currently using right now is Dropbox. And that allows both myself and any of my employees or associates or paralegals to access any document at any time on any device, including their phone. I think that that's a really good system to use, and I would recommend it to everybody. I'm not getting any kickback from Dropbox. I'm just saying it's a good system. It really, though, depends on you scanning or saving everything to file. And now is probably a better time than ever to take the hit, spend 2 or 3 days doing that. You won't regret it.
Okay, thank you. And with that, that brings us to the end of our time. Thank you, Mr. Ivkovich, Mr. Linkseth, and Mr. Amber. This has been very informative. I'd like to thank each of you very much for joining us and sharing this information. And thank you as well to all the attendees for viewing and asking the questions. You can continue to forward those questions if you'd like. Recording of this webinar will be posted on the LexisNexis Canada website as well. And with that, stay safe, everyone, and have a great week. Bye.
Bye-bye.
Goodbye.